we can begin.
Blast off. I'm not Jeff Bezos. I'm Congressman Steve Cohen, and this is the start of the Judiciary Subcommittee on the Constitution, Civil Rights, and Civil Liberties. Today's most important hearing is on the Americans with Disabilities Act, a great act in the 1990s, the ADA. The committee will come to order without objection. The chair is authorized to declare a recess at any time. I welcome everyone to today's hearing on oversight of the Americans with Disabilities Act of 1990, current state of integration of people with disabilities. This is an act that I think Steny Hoyer was the sponsor of, and he's a great patron of. So I recognize Mr. Hoyer at this time. I'd like to remind members we have an email address, which you all know and you hear innumerable times, where you can share distribution of exhibits, letters, written materials, et cetera, et cetera, et cetera. So you got that address. Also, I'd like to ask members and witnesses, both those in person and those appearing remotely, to mute your microphones when you're not speaking. This will help prevent feedback and other technical issues, and you may unmute yourself anytime you seek recognition. I will now recognize myself for an opening statement. Hailed by many as the most significant and comprehensive civil rights statute since the Civil Rights Act of 1964, the Americans with Disabilities Act of 1990 was enacted with overwhelming bipartisan support. The late Senator Edward Kennedy, a lion of the Senate, if not the lion of the Senate, dedicated champion of civil rights and one of the two chief sponsors of the ADA, noted that in passing the legislation, Congress affirmed its commitment to remove the physical barriers and antiquated social attitudes that have condemned people with disabilities to second-class citizenship for far too long. The bill's chief House sponsor, now Majority Leader Steny Hoyer, said in 1990, just before the ADA was signed into law, that the day the President signed the bill would be Independence Day for those who have been disabled. Both Senator Kennedy and Representative Hoyer were right. President George H.W. Bush declared as he signed the ADA into law that the shameful wall of exclusion of people with disabilities finally come tumbling down. The ADA has improved lives of millions of individuals with disabilities by explicitly prohibiting discrimination on the basis of disability and by providing standards and legal recourse for confronting such discrimination when it occurs. The idea that we had a period in our history when we didn't have sufficient parking for people with disabilities, curb cuts, banisters, or help people get up and down stairs, it's hard to imagine. But it goes way beyond that, of course. This nation has made progress in the last 31 years toward achieving the ADA's goals of ending discrimination against and segregation of people with disabilities. The law is yet to achieve its full promise. Indeed, we could devote numerous hearings to many different aspects of the ADA and the various remaining barriers that prevent disabled persons from enjoying the full blessings of American life. It has been a decade since this subcommittee last took a comprehensive look at the state of the ADA's implementation. Given the breadth of potential topics, we have chosen to concentrate today on the ADA's integration mandate as a starting point because community integration is a core goal of the ADA overall. We will look at the Title II of the ADA and the enforcement and implementation of the Supreme Court's Olmstead decision. Additionally, we'll examine longstanding barriers to voting accessibility for people with disabilities. Title II of the ADA provides that individuals with a disability shall not be denied the chance to participate in or benefit fully from the services, programs, or activities of public entities, which include, of course, state and local governments and federal governments. More than 20 years ago, the Supreme Court declared in the Olmstead case that unnecessary institutionalization of people with disabilities violated Title II of the ADA, and that states must ensure that individuals receive services in the least restrictive setting possible. Yet thousands of individuals with disabilities still find themselves in situations where their only option for receiving housing and treatment services are in institutional settings isolated from the community. People with disabilities continue to face discrimination in the form of over-institutionalization, and the COVID-19 pandemic has further exacerbated this problem. As of June 21, over 180,000 people living in institutional settings had died during the pandemic. The pandemic has underscored the urgent need to fully implement Olmstead and to ensure that state transition providing home and community-based services. And I don't know if it's based on anything with ADA, but it certainly comes from that spirit we have in our Build Back Better bill, funding for people to remain in their homes when they get older, which is not necessarily, I guess, part of the ADA, but you get older, that's a disability. You have disabilities too. And you should have home health care and be able to stay in your home. That's something that crosses political borders. Another core goal of the ADA is to ensure that people with disabilities can attain economic self-sufficiency. Olmstead requires states to provide employment services in the most integrated setting appropriate to the individual's needs. Yet persons with disabilities continue to face discrimination in the provision of employment-related services. Many persons with disabilities continue to be employed in sheltered workshops where they're segregated from the rest of the community. They often earn a sub-minimum wage because that is the setting where the state provides employment services. These environments do not aid people with disabilities in achieving competitive integrated employment, which should be the goal. The goal is difficult because it's hard to judge, but we need to look at it. The Department of Justice plays an important role in ensuring state employment services comply with Olmstead. 2017, however, then Attorney General Jeff Sessions rescinded the department's guidance document describing the application of Olmstead to state and local governments' employment service systems. There was no explanation or justification for rescinding this and other critical ADA-related guidance. The department should reinstate and strengthen the Olmstead guidance so that they transition away from providing employment services in sheltered workshops and instead provide supported employment in the community that allow people with disabilities to earn a competitive wage while developing job skills. Also of critical importance to integrating people with disabilities into American society is the right to participate in our democracy. Yet 31 years after the ADA's enactment, people with disabilities continue to face significant barriers to access the vote. We certainly hope our minority members don't find any new ideas for voting laws when we discuss these disabilities, significant barriers. These barriers include physical barriers to in-person voting locations, as well as impediments to voting by mail that particularly undermine voting access for blind or low-vision voters and voters with limited manual dexterity. In 2020, many states implemented changes to voting laws in response to COVID-19 pandemic that, while improving voting accessibility, also highlighted the fact that people with disabilities still face numerous and long-standing barriers to voting. While COVID-19 pandemic voting reforms proved to be an unexpected boon to voter accessibility in the 2020 election, states are now poised not only to erase the gains made by voters with disabilities, but also to direct additional barriers to voting. The subcommittee is dedicated to ensuring that states do not erode the ability of people with disabilities to vote. More than 30 years after the ADA's enactment, the law's implementation has fallen short of its full potential. Many challenges remain to fully achieve the ADA's goal of ending disability-based discrimination and the exclusion of people with disabilities from American society. It's a difficult balancing act. We hope we know we'll hear from the experts on where it falls and what we can do to fulfill the purposes of the law and its intent. This hearing will do that. I welcome our witnesses and I look forward to their testimony. It's now my pleasure to recognize the ranking member of the subcommittee, the gentleman from Louisiana, the state where it's good to be a football coach who's got a good buyout. Mr. Johnson for his opening statement.
Thank you, Mr. Chairman. It's a sore subject. It's too soon. I appreciate everyone participating in the hearing today. And I note that we have a sign language interpreter, Mr. Stubbs, who's trying to keep up with how fast we speak. So we appreciate that. I'll be cognizant of it. We all should. The Americans with Disabilities Act was passed by Congress in 1990 and signed into law by President George H.W. Bush. It was a big achievement. And for 30 years, the ADA's purpose has been to, quote, provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities, unquote. Obviously, that is a noble goal that I think probably all Americans agree with. And of course, we should all strive to ensure people with disabilities can live in their communities and work in their chosen professions to the fullest extent possible. In the more than 30 years since the ADA was passed, however, it has become very clear that the law, subsequent regulations, and jurisprudence have convoluted things to the point where small businesses simply have no clear guidance on what exactly is required of them. Instead of successfully codifying the golden rule of treating our neighbors as we want to be treated, the ADA has resulted in a compilation of vague and often complex standards and balancing tests. This has led to bad outcomes for individuals with disabilities and for businesses which are struggling to comply. As we hear from our witnesses today, people with disabilities still face obstacles in their daily lives. Meanwhile, businesses don't know what they must do to comply with this federal law. As one legal commentator has remarked, quote, because the ADA requirements are both obscure and voluminous, and even compliance experts do not agree amongst themselves how much accommodation counts as enough, potential violations can be found at most businesses, unquote. Businesses regularly face so much uncertainty in how the ADA will be enforced, they are put in the impossible position of complying without even knowing what compliance means. And if businesses mistakenly get it wrong, well, too bad for them, they're punished anyway. It must become simpler than that, and this dilemma must be resolved in the best interest of all Americans and everyone involved. Until it is, I fear that we will continue to fall short of the ADA's goal of eliminating discrimination against individuals with disabilities, and we'll put millions of business owners, employers, job creators, who are operating in good faith in this continued impossible situation. We do thank our witnesses for appearing today, and we look forward to your testimony. With that, Mr. Chairman, I yield back.
Thank you, Mr. Johnson. Are there any opening statements from chairs that we want to introduce? Oh, Mr. Nader, you're here. Sorry, I don't go to my right very often. You're welcome.
Well, thank you, Chairman Cohen, and thank you to all of our witnesses for joining us today. In considering the current state of integration of people with disabilities into their communities, today's hearing provides us an important opportunity to examine the extent to which the ADA has ensured that people with disabilities have access to housing, employment, and voting rights as the law intends. The ADA is one of the nation's most important civil rights laws. 31 years ago, on a bipartisan basis, Congress passed this historic law to, quote, provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities. Yet while the ADA has helped break down many barriers facing people with disabilities, our nation has yet to achieve the law's promise of full integration. Notably, the Supreme Court in its landmark 1999 decision in Olmstead versus LC held that Title II of the ADA, which provides that people with disabilities must have the chance to participate in or benefit fully from the services of public entities, and the DOJ's regulations in interpreting that provision prohibited the unjustified segregation of people with disabilities. Such unjustified segregation, the court held, constituted discrimination and required that states, should an individual not oppose it, must provide community-based services to people with disabilities in the most integrated setting appropriate. The importance of the Olmstead decision to the disability community cannot be overstated. Transitioning people from congregate institutional living or treatment settings has enabled people with disabilities to live better, more independent lives as individuals with the dignity that they deserve, which is one of the core purposes of the ADA. 22 years of experience with Olmstead has not only demonstrated the states can comply with the decision, but also that Olmstead has made state service systems better and more responsive to the individual needs of the people they serve. Moreover, the COVID-19 pandemic has underscored the urgency and necessity of implementing Olmstead. The COVID-19 pandemic has disproportionately impacted people with disabilities, partly due to their overconcentration in congregate settings such as nursing homes or other assisted care facilities. According to the New York Times, as of June 1st of this year, over 184,000 deaths had been reported among residents of nursing homes and other similar congregate facilities. The pandemic has made implementing Olmstead literally a life or death matter. To promote state compliance with Olmstead, Congress should create incentives for states to expand their community service systems. The American Rescue Plan provided a one-year incentive to states to expand home and community-based services by providing an increase in federal Medicaid funding matching for those services. The Build Back Better Act would also make a similar incentive permanent, provided that states meet certain conditions. I hope this will be enacted into law soon. It's also important to recognize that the segregation of people with disabilities is not just limited to where they live or receive treatment, but it can also manifest in where they work. Another one of the core purposes of the ADA is to ensure that people with disabilities can achieve economic self-sufficiency and independence. Yet the majority of people with disabilities are not part of the labor force, and a significant number of those who are employed work in sheltered workshops where they are relegated to performing menial tasks below their capability, sometimes for sub-minimum wages, and segregated from the wider community. To fully realize the ADA's integration mandate, we must also ensure that state employment service systems comply with Olmsted. Rather than provide services in segregated settings cut off from the rest of the community, state employment services should transition to providing supported employment in the community to ensure that people with disabilities can develop the skills necessary to achieve competitive, integrated employment and economic self-sufficiency. Last, but certainly not least, ensuring that people with disabilities are integrated into the community requires that they are fully able to participate in the electoral process. Indeed, as I have stated before, the right to vote is instrumental in securing and defending all other rights. Yet over 30 years after the ADA's passage, people with disabilities still face too many longstanding obstacles to exercising their right to vote. Many of the changes to our voting laws in the wake of the COVID-19 pandemic made the 2020 election more accessible to people with disabilities than past elections. While that perhaps unexpected progress is welcome, it only highlights the continuing and persistent barriers that people with disabilities face when voting. Moreover, as this subcommittee learned during its oversight hearings on the Voting Rights Act this past summer, the current attack on voting rights includes a rollback of those positive voting law changes and would institute additional barriers to voting that disproportionately impact voters with disabilities, and especially voters of color with disabilities. Congress took an important step when it passed the ADA in 1990, but as a nation, we still have a long road ahead to achieving the goal of full community integration. We must continue to ensure robust enforcement of the ADA and compliance with the Olmsted decision across the board. Again, I thank Chairman Cohen for holding this hearing, and I look forward to hearing from our witnesses. And with that, I yield back the balance of my time.
Thank you, Mr. Chair. We will now go into our series of statements from our witnesses, and I shall introduce them before they start their statements. We thank you for participating today and introduce each of a second. Your written statements will be entered in the record in their entirety. You have 5 minutes to summarize your written statement or to provide it here today. There's a timer in the Zoom view that should be visible at the bottom of your screen if you are with us on Zoom. Shows you how much time you have left. To help stay within that time, that should be visible at the bottom of your screen. I'd like to remind all the witnesses appearing that you have a legal obligation to provide truthful testimony and answers to the subcommittee, and any false statement you make today may subject you to prosecution under the United States Code. Our first witness is Ms. Patricia.
And now what he wants to do, and I work in the afternoon too, so it has to be in the morning. So now we're down to Monday.
Everybody mute. I think we got that. Our first witness is Patricia Lee. Ms. Lee is a resident of Lumberton, North Carolina. She formerly was a resident of an assisted living facility, and she faced many obstacles to rejoining her community because of mental disability and history of substance abuse. Because of the ADA, she received necessary resources that empowered her to move into her own house in her local community. She's accomplished many milestones in pursuit of her goals, such as driving a car and finding a career, and she's here to share a story with the subcommittee. Ms. Lee, you are recognized for 5 minutes.
Thank you. Good morning. My name is Patricia Lee. I live here in North Carolina, and I'm here to talk about how the Americans with Disabilities has significantly changed my life. Because of the Americans with Disability Act, I've had an equal opportunity to turn my life around. I have a history of substance abuse and mental health diagnosis, and I found myself in a situation where the only housing I could obtain was an assisted living facility. This was put into place by my doctor because I was going to end up on the streets where I would probably begin using again. The doctor thought that the assisted living facility would be able to treat my mental health diagnosis as well as maintain my recovery. The assisted living facility was very depressing. If you know anything about people who are in recovery, it's very important that we don't experience severe depression. This makes people more likely to use again. The only good thing about that place was that my mother was in the room next to me, and the most depressing aspect was the way I saw staff treat other people. It was just too much negativity to be around. I honestly thought that my end result was an assisted living facility. A lawsuit found that mental health services in North Carolina were violating the Americans with Disability Act and not providing needed services for people with mental health diagnosis to be successful in the community. To meet the terms of the lawsuit, East Point came in and asked me, did I want to live on my own? I didn't think that was an option for me anymore. East Point helped me get a house that I still live in. They showed me the house and I approved of it. There was a chance that someone else could have gotten it, so I looked at a duplex as well. Once I moved in, I decided to set a goal to get an emotional support animal, and that's how I got my dog, Lady. I received mental health services from Stevens Outreach Center and transition support from East Point, and others that include a therapist, peer support, specialist, rental assistance, and any other support needed to help me set my goals and reach my goals. My faith has played a large role in my recovery as well. Through my faith, I have a family who is always there. My faith in Jehovah has helped me persevere. When I was living in the assisted living facility, I received less services for my mental health, and there were always appointments that were canceled and never rescheduled while I was in the assisted care home. The appointments were even set beyond my control. So now I receive all the support I need from the Community Inclusion Pilot Program with East Point and Alliance of Disability Advocates of North Carolina. I had a goal of paying off my court fees that I got when I was not in recovery and getting my driver's license reinstated. I've been able to pay off the debts completely, and when I got one of the last debts paid off, I was suddenly told of a class that I needed to take in order to get my driver's license. This was devastating as I had been saving just to pay off the court fees, and now I had to pay $1,000 in order to take the class. Fortunately, it was around the same time that a program called Freedom Funds was available. Freedom Funds helped me with this expense, and I have completed the class, and now I only have to take my test. Freedom Funds comes from the Community Inclusion Services. This program has enabled me to move out of the facility and into my own house. I still receive needed services such as counseling, peer support, and anything I need to reach the goals that I set for myself. I have successfully lived independently for almost 4 years now. Through mental health services in the community, I still have the support that empowers me to reach my goals. Thank you.
Thank you, Ms. Lee. Appreciate your testimony and your success and your opportunity to have your home and what you need. Our next witness is Regina, who goes by Regina Klein. Ms. Klein is the founder and CEO of Smart Job, a global company with a core mission of closing the disability wealth gap by making jobs smarter through expanded investment, access to financial services, and better public policy. Ms. Klein previously served as senior counsel to the Assistant Attorney General for Civil Rights during the Obama administration, where she provided legal and policy counsel regarding efforts to implement the ADA. She filed and resolved the nation's first cases under Title II of the ADA and the Supreme Court's Olmstead decision to challenge segregated work settings. She received her degrees from the University of Maryland School of Law, making Steny Hoyer very proud, and from Columbia University, making Chairman Nader proud. Ms. Klein, you're recognized for 5 minutes. I think, there you go.
I hope that I've corrected my mute problem. Thank you very much, and I'm very happy to be here. People with disabilities are a constituency that includes nearly 1 in 5 Americans. This constituency comprises nearly half of those Americans that live in long-term poverty. We're talking about nearly 2/3 of working age people with disabilities who are in fact not employed. So in short, this is an unemployment crisis of profound proportions, and it has direct ramifications for the economy. But crucially, in the United States, this disability unemployment crisis has been deepened by public spending, namely this significant over-reliance of state and local governments on service systems that structure employment, in employment service delivery for people with disabilities in separate, segregated employment settings, apart from mainstream competitive employment and typical jobs in the open market. And this violates the mandates of the federal civil rights laws that were just explained, namely the Americans with Disabilities Act and the Supreme Court standard that was set forward in the Olmstead versus LC decision. And while plaintiffs' counsel and the Department of Justice have worked vigorously over roughly the past decade to rectify these failures through enforcement of Title II of the ADA and Olmstead, there's much work left to be done in the country. There is a multi-billion-dollar public service system that largely still significantly relies on separate, segregated both employment and day settings for service delivery in lieu of investment in integrated alternatives that include supported employment services and the types of supports that Americans with disabilities need to find, obtain, and sustain typical employment in the community. This bitter reality remains. And so the core recommendations that I provided in my much longer written testimony include that the DOJ reinstitute and reinstate this critical guidance that explains Title II of the ADA and Olmstead to public entities. That guidance that was rescinded roughly 5 years ago provided technical assistance and understanding to state and local governments as to how to comply with these core requirements of the ADA. The second recommendation is to encourage states to make use of American Rescue Plan dollars in order to fund critical home and community-based services to support the population of Americans with disabilities who can and want to work to transition into typical employment at this crucial and pivotal moment in the pandemic, instead of being reinstitutionalized or returning to separate segregated settings where typically there is the payment of sub-minimum wages and a lack of training and support to re-enter the market. And finally, the DOJ should continue to prioritize and vigorously enforce Title II of the Americans with Disabilities Act and the Olmstead decision as applied to employment. I do not have knowledge of any recent enforcement actions from the DOJ applying Title II of the ADA to employment. However, I am aware of some truly amazing and considerable progress as it relates to enforcement of existing consent decrees. So those are the recommendations, and this is an issue of critical importance to millions of Americans with disabilities who now during the pandemic, for the first time in quite a while, have the opportunity to reassess whether they can and want to work and need the supports from state and local governments to work.
Thank you. Our next witness is Karen Harned. She is Executive Director of the National Federation of Independent Businesses, Small Business Legal Center, a post she has held since 2002. In that role, she comments regularly on small business cases before federal and state courts. Prior to joining NFIB, she was in private practice and worked for U.S. Senator Don Nichols of Oklahoma as Assistant Press Secretary. She earned her JD from the George Washington University School of Law and her BA from the University of Oklahoma. Ms. Harned, you are recognized for 5 minutes.
Thank you, Chairman Cohen, Ranking Member Johnson, and the members of the subcommittee. On behalf of NFIB, thank you for asking me to testify today regarding the Americans with Disabilities Act. Small business owners are proud of the commitment they have made to accommodate the disabled. NFIB members have spent millions of dollars constructing and or renovating their businesses to remove barriers and provide accessible accommodations. Unfortunately, many small business owners do still struggle to understand when and what structural and online changes are required due to the highly technical nature of the ADA standards for brick and mortar businesses, no legal standards for websites, and enforcement that is primarily done through private lawsuits. When it comes to regulations, small business owners bear a disproportionate amount of the regulatory burden. The small business owner is the chief compliance officer for her business and consequently significantly faces significant headwinds when navigating any regulatory regime, particularly one as complex as the ADA. Title III prohibits discrimination based on disability in places of public accommodation. But many small business owners rent space in facilities and buildings that were constructed decades ago and subject to the ADA's barrier removal requirement. DOJ has, in practice, defined a barrier as any element of a public accommodation that does not comply with the extensive and detailed requirements of the ADA standards for accessible design. This is a document that even a lot of lawyers have trouble understanding. To comply, small business owners have to hire an ADA consultant to determine what barriers exist and an ADA lawyer to determine when barrier removal is readily achievable. Adding to the confusion, many state and local building codes continue to allow for the grandfathering of older facilities, but the 2010 ADA standards do not. So it is easy to see why the owner of a small bookshop on Main Street can think she is complying with the law and up to code, but really be in violation of the technical ADA requirements for barrier removal. When it comes to websites, the text of the ADA provides no clear guidance on its applicability to the internet, so the courts have been forced to weigh in. While they have generally found that the ADA applies to websites, they disagree on just what is required, and neither Congress nor DOJ have stepped in to answer this important question. Private groups have filled the void with what are known as web content accessibility guidelines. These are extremely technical and could cost thousands of dollars or even more to implement. Given the lack of clear standards for barrier removal and website accessibility, the primary method of Title III enforcement has been through private plaintiffs in the courts. 2021 marks a record high for this type of litigation, which is often motivated by financial gain instead of accessibility for the disabled. The high cost associated with litigation does nothing to improve access for disabled customers, but a lawsuit over the slightest deviation from complicated ADA guidelines, or worse, website standards that don't even exist, can prove disastrous for the millions of small businesses across the country who do not have compliance officers or attorneys on staff. NFIB strongly encourages Congress to enact the ADA Education and Reform Act of 2017. It was introduced in the last Congress. It would provide small business owners time to remedy alleged ADA violations before being forced into a settlement or a legal challenge. And Congress also should pass legislation clearly defining its intent with regards to websites under the ADA. Accessibility makes good business sense. The ADA needs to be clarified and enforced in a manner that benefits the disabled by providing access without putting well-meaning small business owners out of business. Thank you for the opportunity to testify today, and I look forward to any questions that you may have.
You're welcome. Thank you very much. Final witness is Michelle Bishop. Ms. Bishop is the Voter Access and Engagement Manager of the National Disabilities Rights Network, where she's responsible for coordinating voting rights initiatives in every U.S. state, district, and territory, as well as providing training and technical assistance on the nationwide network of the National Disabilities Rights groups and members regarding voting rights and access for voters with disabilities. She received her Master of Social Work and Social Economic Development from the Brown School at Washington University in St. Louis, and a Bachelor of Arts in Sociology and English Literature from State University of New York at Geneseo. Ms. Bishop, you are recognized for 5 minutes.
Good morning, and thank you for the opportunity to testify today representing NDRN, the National Disability Rights Network, which is the nonprofit membership organization for the federally mandated Protection and Advocacy, or P&A network. The United States Government Accountability Office has studied polling place accessibility for 20 years. In 2000, GAO found that only 16% of polling places had an accessible path of travel from parking to the voting station, 27% in 2008, and 40% in 2016, still less than half. Voting stations and equipment dropped from 54% accessible to 35% in 2016. Combining this data, only 17% of America's polling places are accessible. As I have stressed to members of Congress before, America's polling places are woefully, inexcusably, unjustly out of compliance with the ADA. Alarmingly, 13 states closed an overwhelming 1,688 polling sites in just 6 years, often blaming the ADA. NDRN examined this issue in depth and found that jurisdictions that settled with DOJ in the last several years were working to find innovative solutions to avoid poll closures while increasing accessibility. Alternatively, jurisdictions that closed polling places citing the ADA typically were not under a settlement agreement with DOJ and could not provide proof of inaccessibility. Turning our attention from in-person to remote voting, traditional vote-by-mail systems are not and have never been accessible to voters with disabilities who cannot privately and independently mark, verify, and cast a paper ballot. Increasingly, people with disabilities have been given access to electronic ballot delivery systems typically reserved for military and overseas voters protected by UOCAVA. This is a promising practice, but these systems often require the voter to print and return a paper ballot, reintroducing inaccessible paper to the process. Pivoting now from these long-standing accessibility barriers to take a closer look at 2020, the pandemic created shortages of polling places and poll workers, which complicated in-person voting. Elections officials found themselves unprepared for a significant increase in voting by mail, and as nursing homes were forced to close their doors, guidance from the Centers for Medicare and Medicaid Services reinforced the obligation to staff to facilitate voter participation among residents. However, relying on an overworked staff on the front lines of a global pandemic revealed how genuinely tenuous voter access is for residents of long-term care facilities. Smart jurisdictions made rapid changes to their election policies to meet these demands, which had a side effect of improved accessibility. 42 states offered a significant period of early voting. Some states also implemented curbside voting or extended it to all voters, opened up absentee voting processes, allowed voters to use electronic ballot delivery, and all but 10 states offered ballot drop boxes, the most in any American election. In the aftermath of COVID-19 creating more accessible elections, states across the US have seen legislation introduced that threatens the progress made during the 2020 election cycle. By October 2021, 19 states have enacted 33 laws that will negatively impact the accessibility of the vote, including reducing locations or hours for polling places, increasing the number of voters per precinct, limiting early voting, prohibiting curbside and drive-through voting, preventing distribution of food and water to voter lines, shortening the window to apply for a vote-by-mail ballot and timelines for ballot return, creating stricter signature match requirements for vote-by-mail ballots, imposing limits on drop boxes, making it more difficult to remain on absentee voter lists, or limiting who can assist a voter to return a ballot. Ultimately, the ADA has been and continues to be the gold standard in protecting the right to vote for people with disabilities. Congressional funding is sorely needed to help election administrators to improve accessibility and for the PNAs to provide them with invaluable consultation. In this vein, Congress must act now to reintroduce and pass the PAVA Inclusion Act and provide the last 2 excluded PNAs with desperately needed HAVA funding, a simple and no-cost legislative fix. Congress must also amend the Freedom to Vote Act to allow voters with disabilities an exemption from nationwide paper ballot mandates that will disenfranchise them. Creating a legislative carve-out for people with disabilities, in addition to a periodic reauthorization or a sense of Congress to reconsider the need for a paper ballot mandate, will allow voters with disabilities who need it most to access the same technologies we allow for UOCAVA voters. We are willing to take a limited, calculated risk to ensure that our deployed military will have their voices heard on Election Day. We must be willing to do the same for people with disabilities. Finally, Congress must now act to pass the John Lewis Voting Rights Advancement Act to prevent known discriminatory practices. These problems are solvable, and after 30 years of the ADA, there is no excuse for not having addressed them. I have said it to the subcommittee before, but it bears repeating. We call them Americans with disabilities because they are, first and foremost, Americans. And America's democracy is only as good as its ability to hear the voices of all Americans. Thank you.
Thank you very much. Apparently, the interpreters are following Mr. Johnson's earlier importunation, and people are talking too fast. So we need to talk slower. Thank you. I will normally go first for questions, but with this new requirement that we talk slower, I will yield to Mr. Nadler for the first question.
Thank you. Ms. Lee, why is living independently important to you? Ms. Lee? Oh, the time is...
Living independently gives me a sense of accomplishment. And that's the best way to say it.
Okay, and Ms. Bishop, one of the ADA's purposes is to invoke the sweep of congressional authority in order to address the major areas of discrimination faced day to day by people with disabilities, unquote. Why is ensuring the right to vote for every American with a disability essential to fulfilling this purpose? And how should Congress be invoking its authority to accomplish this goal in terms of the right to vote?
I think that Congressman John Lewis said it best when he said that the right to vote in America is one that is almost sacred. It is the foundation of all of our other rights, and people with disabilities have to be able to participate in the democratic process to ensure that their rights are going to be protected. I think Congress has a role to play in ensuring that the ADA, which works, is being enforced, and in providing funding and support to our nation's election officials to help them to meet demands, as well as looking at the complicated patchwork of other federal legislation that also supports the right to vote for people with disabilities, including passing an amended version of the Freedom to Vote Act, as well as the John Lewis Voting Rights Advancement Act.
Thank you. And Ms. Klein, in September, this past September, the civilian labor force participation rate was 22.3% for people with disabilities, compared to 67% for people without disabilities. Why do you think there's such a large discrepancy in these labor force participation rates?
Yes, thank you for that question, Congressman Nadler. In truth, there's been a nearly 40-point percentage gap for decades as between people with disabilities and people without. This is an ingrained systemic injustice that has to do with where we invest. And when we invest the majority of our service dollars in separate segregated settings where people spend the majority of their days for the majority of their adult working years, the results that we get are low labor force participation. In addition, we have very little to show in terms of public investment in the types of skills that are most catered to new and emerging industries in this utterly disrupted knowledge-based economy. We are vastly overinvested in manual skills training in separate settings. And as a result, we have seen very little breakthrough in terms of that labor force participation rate over time.
What should we be doing instead?
What we should be doing instead is providing guidance and support to those state and local systems that want to rebalance and shift their service systems to resource those that are in advancing the solutions to supporting workers to come into typical jobs. What that means is supporting job coaches, job developers, benefits counselors. We're talking about shifting the lion's share of public service dollars from supervision and support in separate settings to supporting workers to find, obtain, and sustain employment in jobs that match their skills and talents. This is not something that happens lightly. This is something that takes the intentionality of the public system working together with private employers. But here's the good news. Private employers are in search of talent today and have been for quite a long time in search of diverse talent, including people with disabilities. Our talent pipelines are caught up, held captive in this system that is actually channeling workers with disabilities out of secondary school, around the United States and directly into segregated programs instead of typical employment. And so it's a challenge to support those service providers within state systems to support workers to move into competitive integrated employment.
Thank you. And finally, can you describe what segregated employment settings look like and how they're at odds with the ADA?
Well, segregated employment settings take on many of the institutional attributes that are recognized in residential settings. That means that there are people with disabilities congregated with each other without people without disabilities in the employment setting, except typically paid staff, paid support staff. One of the indicia of this segregation and one of the factors that shows how out of step with economic self-sufficiency these settings are is that they so often pay sub-minimum wages. How could this be in 2021 in step with the meaning and purpose of the ADA and Title II that we have Americans earning less than minimum wage in these settings?
Well, thank you. I just want to say that I certainly think we ought to outlaw sub-minimum wages, and I thank you, and my time has expired. I yield back.
Thank you, Mr. Nader. I'd now like to recognize Mr. Johnson for 5 minutes.
Thank you, Mr. Chairman, and again, all of you for participating. I had a couple questions for Ms. Harned. Is it your experience that most small businesses really do want to comply with the ADA?
Oh, absolutely. And if you go into any business, or I shouldn't say any business, but the businesses I've gone into, the members I've talked to, that's actually one of the questions I ask them, because I know this area of the law is complicated. And they're like, oh, I'm up to code. Yes, I'm, compliant. And that is why it's so frustrating to me and frustrating to them, because they're thinking in many instances that they actually are doing the right thing. Because of course, before you go into your place of business, you're going to have a business, you're going to have it inspected, right? And so that's where I think we're still not there yet on all of us being, on the same page as to what it takes to be compliant with ADA.
And really, that's a primary point. There are a lot of incentives to comply, not just to comply with the golden rule and do the right thing, be a good corporate citizen, but there's an economic incentive as well, because you want to provide for as many customers and clients, et cetera, to access your business as possible. It just follows common sense. But earlier this year, the National Federation of Independent Business released a white paper on the lack of guidance businesses have received from the government on how to make their websites ADA compliant. That's just a case in point. And the paper said businesses were left with a mandate that essentially says, quote, comply, but we won't tell you how to comply and what compliance means, unquote. So can you explain a little bit about this uncertainty in this area, for one example regarding websites and how that affects small business?
Correct. Well, this is nothing short of, to use a term my kids would use, a hot mess. There is no legal standard for what it means to comply, to have your website accessible. And so the courts have stepped in, and the answers are all over the place. The circuits are split on what's required. The Department of Justice really has not been very helpful in providing any answers. And so you're really seeing, particularly in this space, a lot of predatory litigation. I mentioned in my testimony the story of a business owner I just recently heard from that's part of a class action lawsuit. And he is, the way he speaks is definitely the way our members speak. He said, I try to do everything the right way. I try to be on top of all the laws, but I have no law I can comply with here. And he's just extremely frustrated. So yeah, that is a big area of, it's becoming a bigger problem each and every day, quite frankly.
It is, and you've noted, and we all recognize, common sense tells us, experience tells us, most small businesses obviously do not have compliance professionals and lawyers on the payroll to help them navigate all these various laws and rules. And as you mentioned, even when they make a good faith effort to comply, even when a small business does hire a consultant, other professionals, somebody specializes in ADA compliance, that's not even a panacea, because they can still be found in violation. So they're in a tough spot. You proposed today some practical solutions. One of them I note was you were talking about providing an expanded period to allow for compliance by a willing business before these punitive damages are assessed. Could you explain that just a bit more and how it would help?
Right, and I understand for members of the disabled community, they might react, "Oh, it's 31 years. Your business should be, I mean, this should not be an issue anymore." But honestly, I know of business owners that have done what they thought was required under the law using an attorney only to find that they were sued because a guardrail was a quarter of an inch off, which I recognize again may be a lot for a member of the disabled community. I'm not saying that's not real, but what I am saying is that a small business owner, is not going to know that level of technicality, and they could receive bad advice. The bad actors are not going to, they don't care. I mean, if I'm being completely candid, but most small business owners do care. And if you tell them what they're doing wrong, they'll fix it.
That's been my experience as well. And I think the goal of all this, every one of us, this is not a partisan issue. We want disabled Americans and everyone to have full access and the ability to, patronize businesses and do everything that everyone else can. And we want the businesses to thrive as well. We want all boats to rise together. But in order to do that, we have to apply common sense. We have to modify some of these rules and regs and make it possible so that we can achieve all those goals simultaneously. These are not mutually exclusive pursuits. And I think we do well to recognize that. I think Congress has a role here to help, and I hope that we will. I'm out of time, unfortunately. I yield back, Mr. Chairman.
Thank you, Mr. Johnson. I'm going to take my 5 minutes and ask a few questions. Ms. Klein, I think it was your testimony concerning the employment locations where folks are just congregated without to do work and paid sub-minimum wage. Was it you or was it Ms. Bishop that testified about that?
That was me, Mr. Chairman. Thank
Good.
you.
I mean, what are some of the groups that have that type of employment situation? There's some kind of well-known groups in the community, well-known, but I don't recall them, not that well-known, but pretty well, that have shelters and provide this work for people with disabilities, which, as I recall, when I visited, this has been many years ago, that they seemed to be doing a good public service. Who are those groups?
Well, Mr. Chairman, that's an interesting question and one that's often asked. These service settings are prolific, and there is no particular group that I would isolate other than to say to you, this is an 83-year-old practice, the origins of which are embedded in the New Deal. There's no doubt in my mind that you've seen these groups over the years, and that many people who've explored people with disabilities who are working have seen them working in separate settings. But it is a historical anachronism to say that we set it and forget it. The moment has come, and there's no particular group to isolate. This is a question of priorities of spending and supports. And people with disabilities have an archaic and pretty much fossilized service system for employment at the precise time when there's a labor shortage, at the precise time when other workers in the global economy are reassessing their skill development, are reassessing their interests and preferences for employment. And we've got to get moving on this goal. It is the time to evaluate.
Ms. Klein,
Yeah.
I understand what you're saying in theory, and I accept it, but I'm just trying to recall. I mean, some of these groups seem to be very well intentioned and very well respected in the community, and a lot of the people that were working there looked to me to be very seriously disabled, to where they probably could not work in a different setting. There is a standard by which some of those people could continue to work in those settings, because otherwise they wouldn't probably be able to work at all. Is that not correct?
Well, federal courts have recognized, and the ADA itself has explicitly recognized, that we should not give regard to whether someone can work or not without providing them an individualized assessment of their skills and their functions on the job in employment. And actually what we've done is we've referred many people to these settings without a unique understanding of their skills. We don't know. What we do know with particularity is that many people can and want to work in other settings, but because of the significant excessive over-reliance on these settings by state and local governments, people have been channeled to these settings.
Ms. Harned, let me ask you that. Are you familiar with any of these particular groups that provide this disability shelters. They're shelters, I think they're called. Are you familiar with those groups? Are they part of NFIB or at all? Ms. Harned, are you there? You're muted.
I apologize.
There you go.
I am not personally familiar with these groups. No, I'm sorry.
Okay, sorry that didn't hit you with that. But whatever, I just, I want to see this work, but I also know that there are situations to where some of those groups are doing good things. They maybe should pay minimum wage. Minimum wage is absurdly low right now, and to pay less than that, it's almost infinitesimal to determine something less. But I think that the people a lot of the folks who work there, I don't know if they have cerebral palsy. I think there's one that particularly, and then other disabilities where they might not otherwise have any kind of meaningful activity, and it seems to, you don't want to throw the baby out with the bathwater, because some of it's, I think, probably good. On voting.
Mr. Chairman?
Sure. Ms.
Oh,
Klein.
apologies. If I could just respond, just one more response to that comment, which I think is useful, is that the goal of many of the current legislative proposals towards spending new public resources to support people in their transition is this concept of providing career development planning and really getting to the bottom of what people can and can't do. We haven't done that yet with the level and the capacity that we need in order to support people towards their employment goals. It is not painting with a broad brushstroke about what, the validity of a particular provider. It's empowering that provider to support people in their interests, in their preferences towards employment.
Thank you. I'm going to recognize Mr. Owen in a minute, but I just want to, one question, ask for a brief answer if I can. Ms. Bishop, you talked about voting. Have any of the places, I can see a problem when you've got like 200 voting precincts and they all ought to be compliant and make it easy to vote and not have barriers. But have any districts tried to get around this by having a central location and allow people with disabilities to come to some particular location that might be totally set up for people with disabilities and have all of the barriers removed?
I think the closest thing that we've seen to that thus far is states that move to a vote center model, which is not exclusive to voters with disabilities, but open to all voters. I think that they come with their pros and cons. It does give you the opportunity to pick out your most accessible locations and rely on those. But we do have to be very conscious of how many vote centers we have, how far they may be from voters with disabilities, how accessible they are according to public transit, accessible public transit, to make sure that they're going to be effective. The one thing I think we would discourage is having a separate vote center specifically for people with disabilities when we're really trying to have the most integrated experience possible for voters with disabilities, rather than separating out how they vote from other voters.
Thank you. And that over my 5 minutes by far, I apologize. Mr. Owen, you're recognized for 5.5 minutes. Burgess, we're on.
Thank you, Mr. Chairman. First of all, I want to just kind of echo what the ranking member said. This is really something that is very nonpartisan. We all can agree on the benefits of ADA and what's done to help those vulnerable. My message will be making sure that we have a balance, make sure that our small businesses can continue to grow, because that truly is what creates this culture, this great culture we have called the American way. And I want to start off saying, Patricia, thank you for your story. You're a remarkable example of the American way, again, second chances, and what can happen when you can truly get support and you believe in self-sufficiency, which you're in the process of doing. My dreams and hopes, and I don't know if you ever thought about it, but one day to be in a position to start your own business one day. I mean, that's kind of what we're really all about. And I want to say this real quickly about my upbringing, because the small business owners is truly what makes our country what it is. And I grew up in the 60s where 40% of Black Americans were business owners. In our segregated community, we had them all over the place. That 40% equated to 50 to 60% of Black Americans across our country being middle class. And it's that middle class that powers this great culture that we look at that's full of service and commitment and innovation and all the great things that we feel about our country comes from that powerful middle class. And we have to make sure that we do not do anything that will diminish that. Right now, my community, that great community I just talked about, is now down to 3.8% business ownership. And so you don't have the same innovation, you don't have the same success story, the same mentorship that I grew up around. So that being said, I think what it comes down to the ADA is we have to make sure, and anything we have in which we're looking for the benefit of protecting the vulnerable, that we also protect those vulnerable business owners that really give us this opportunity to hire people like Patricia or anyone else out there that they can actually build a business in. And I have some real concerns about what I see as predatory lawsuits. And this, Ms. Harned, if you would mind answering this question for me, to your knowledge, are Black business owners a popular target for predatory ADA lawsuits and demands? Have you seen that happen by chance?
Well, I don't know specifically about Black business owners. I will say what we've seen, particularly in California, where this has been a tremendous problem for decades, there are a lot of not business owners that English is not their first language, where they do tend to be hit more than others, I would say. And I find that very disturbing, quite frankly. I really encourage anybody to look at the standards, the document. It's 200 pages long, and it really is highly technical. And I think that is one of the reasons why it's just so easy for small business owners to be victims of these lawsuits.
Yeah, and I probably should transition from Black to minority. For those who are maybe first-time business owners, those who get the dream, but they just want to move out, they're not, don't have the legal background, but just have the dream they want to move forward. And those are the ones that are most vulnerable because they don't know. They do their very best. Let me see here. Are you able to, okay, when a business is targeted by any of these lawsuits, they cannot afford to pay attorney's fees associated with the lengthy, expensive litigation. What are recourses that they do have in your experience, what you've seen with any minority or new businesses getting started with these types of onerous litigations?
Well, a lot of the attorneys that practice in this area, quite frankly, again, these would be those that are really, I think, more interested in their own financial gain than maybe the end goal. And they know that these small business owners cannot afford to litigate these suits going in. So they'll send demand letters and say, we went by your business and this is off or whatever, and give a few things and then say, if you don't pay us X amount of money by X date, we're going to bring you to court. So there's not even a follow-up later as to see if the business owner even fix it. It's all about trying to extract the funds because honestly, our research has shown that small business owners just don't go to court. They're going to settle these suits. And a lot of these drive-by, these lawyers that do these, what are called drive-by lawsuits that are well documented, that is their mode of operandi.
Okay, I think it's important to lay it where it is. These are predators. These are people who look at vulnerable businesses, those who cannot afford, and they know what they're after. They're not looking for the benefit of those who need the support. They're looking for their own monetary gain. So I think we should really keep that in mind. Again, it's a very nonpartisan process, my friends. Let's make sure that those who need the support, those who are vulnerable citizens of our country, get what they need. At the same time, small business owners, they're the ones that give the best service you can possibly find. They want their customers to continue to come back. Let's make sure they continue to thrive and our country moves forward as they do so. So thank you so much, and I yield back to the remainder of my time.
Thank you, Mr. Owens. Ms. Ross, gentlelady from North Carolina is recognized for 5 minutes.
Well, thank you so much, Mr. Chairman. I wish I was in the room with you. We're juggling multiple meetings, but this is such an important one, and particularly in North Carolina. And I wanted to thank Ms. Lee for being with us. It means a lot to hear a story from North Carolina, and I'll ask you a question in just a minute, so get ready. The Americans with Disabilities Act was designed to ensure that disability is no barrier to opportunity and that people with disabilities are fully integrated members of society. And since the law was enacted, our nation and our economy have benefited from the contributions of tens of millions of Americans with disabilities in our workforce and in our communities. And yet countless incidents, including in my home state of North Carolina, continue demonstrating that the ADA was a milestone, but not the end of our fight for equality for people with disabilities. Recently, a blind man in Winston-Salem, North Carolina, named Wilmer, was denied entry into a store with his guard dog, Fort. Not only once, but twice in the span of a single month. The second time, the local police were called and threatened Wilmer with arrest, simply for shopping with his guide dog. Disability Rights North Carolina has filed a federal complaint for Wilmer, arguing that the officers violated the ADA. This incident demonstrates how pervasive discrimination against people with disabilities is ongoing. 31 years after the enactment of the ADA, far too many people are unaware of the accommodations legally required for people with disabilities. In order to keep our promise to people with disabilities, we need stronger enforcement of the ADA to ensure that everyone can fully participate in public life. I'd like to ask Ms. Lee how important it is to have those community services so that you can live independently. I know in North Carolina, we had a history of institutionalizing people and then putting them in assisted living facilities rather than investing in community supports. And I would love to hear your story about how important it is to have those community supports.
Without those supports, I don't see where I would be reach the goals that I've been able to reach.
Well, thank you so much. My second question is for Ms. Klein. Just this week, I visited a service industry for people with disabilities where they pay more than minimum wage, give full benefits, are located near a transit stop. It's called LCI Industries, and they contract with the military to provide beds for the Navy. They make all sorts of supplies under federal contracts. Could you tell me how you see these kinds of facilities functioning and how they differ from the ones that you see as problematic?
Thank you, Congresswoman Ross. Each instance requires, more of an acute awareness of the factual circumstances of that provider. And so I feel discomfort in weighing in on the nature of their service provision. The one thing I will say to you, though, that's quite relevant to your question is we are making significant progress, including in federal procurements. Just this month, in honor of October being National Disability Employment Month, the Ability One Commission, which manages over $3 billion in federal procurements, has issued a proposed rule moving away from sub-minimum wage and in support of moving more towards integration. How that looks over time and what happens to the rule yet remains to be seen, but it's a considerable statement of progress towards the acknowledgement that what is typical is the goal, that that systems should be realigned towards the goal of what is typical, including the indicia of integration. So I think that we're seeing the needle move. Every instance requires more knowledge about what the particular services that are being provided are. But the point is that we are starting to come to grips with the fact that we've got to get the end game in mind first. And it is integration and move service and realign services from there.
Thank you, and I yield back.
Thank you, Ms. Ross. We now recognize for 5 minutes and 13 seconds. Mr. Hank Calvin Johnson.
Oh, thank you, Mr. Chairman. Wasn't quite ready to be called on, but I want to thank you, Mr. Chairman, for holding this hearing, and I want to thank the witnesses for their testimony today. My colleagues on the other side of the aisle throughout the pandemic have been strong proponents for schools being open for in-person learning. And after Democrats passed the American Rescue Plan and we finally started getting shots in arms, Republicans started fostering vaccine hesitancy. And as we started getting kids safely back in schools, my friends across the aisle should have been happy, yet despite the CDC recommendations that for in-person learning, universal indoor masking should be required for all teachers, staff, students, and visitors to K through 12 schools, regardless of vaccination status. As of September 29th, Republican politicians in 9 states have banned school districts from setting universal mask mandates. Mrs. Klein, do local and state bans on mask mandates make it more difficult for students with disabilities to return to in-person learning? And based on your experience, how can the Department of Justice help ensure that civil rights of persons with disabilities, especially students, continue to be protected, and that states and localities are mindful of their obligations under Title II of the Americans with Disabilities Act?
Yes, and thank you, Congressman. As you know, my background is in with particularity to employment, but I'm happy to weigh in to honor your question to the extent that I can.
Thank you, I appreciate it.
Yes, one thing that's clear from the pandemic is that people with disabilities have been disproportionately impacted. A lesson learned is that congregation is dangerous. It imposes safety risk. The advocates have long understood that about congregation in segregated settings. It became clear there was a prism or a magnifying glass on that issue as it relates to segregated settings during the pandemic, obviously because of an airborne virus. As it relates to schools, the same is true that there are many students with disabilities across the country that deserve equal access to education in the least restrictive environment. And students who are particularly vulnerable to the idea that there would be health risks imposed upon them by these policies. So the goal of Title II is to ensure integration. The goal of the ADA is to ensure equal access. The goal of the IDEA is to ensure equal access to education. So that's a generalized response to your statement, I understand. But this is complementary to the goal of the ADA is to provide students with disabilities access to education at this time.
Thank you. And imposing bans on mask mandates hurts the ability of disabled students to return to school safely. Is that true or is that false?
Yes, if I sounded at all equivocal, the answer is yes.
Thank you. With regard to voting rights, it seems that after Trump lost the 2020 election in a landslide and after the big lie and the insurrection, the right to vote has once again come under relentless assault in states led by Republican politicians looking to remain in power despite the demographic shifts occurring throughout the nation. But I don't think every American truly understands the extraordinary efforts many disabled voters must take to exercise the fundamental right to vote. Ms. Bishop, what discriminatory barriers have persons with disabilities historically faced when attempting to vote? And how do unnecessary and punitive restrictions on voting by mail impact accessibility when it comes to voting as a disabled person?
I think when we talk about the barriers that voters with disabilities face, the answer is just about everything. Every method of voting, in person, election day, early voting, voting by mail, even getting registered to vote, still has some existing barriers for at least some people with disabilities, because we've really yet to fully realize the promise of the ADA, as well as the Help America Vote Act, to make the process fully accessible and fully integrate voters with disabilities. You talked about vote by mail. And I think some of the things that we did in 2020 in response to the pandemic were really important for making vote by mail work for more voters. We relaxed some of those deadlines by which you had to apply or return your ballot. We relaxed some of the requirements around having witness signatures, notaries, getting a doctor's note to attest that you have a disability in order to vote by mail, things that are just extra hoops for voters with disabilities to have to jump through. And it can be a barrier for any voter, but for a person with a disability for whom those things may not be readily available, for whom transportation could be a problem, it just is that much more difficult. The last thing I want to stress is that we have seen an increase in allowing voters with disabilities to use electronic ballot delivery that we usually use for our military and overseas voters, which allows them to receive and mark their ballots electronically, because mailing them a piece of paper is never going to be accessible to everyone. I think that's something that we really have to look at expanding nationwide. It's something we're willing to do for our military and overseas voters. We should be willing to do it for people with disabilities who are stateside as well, to ensure that they have access to the vote.
Thank you, and I yield back.
Thank you, Mr. Johnson. Good to hear from you. And good that the Dodgers had Cody Bellinger yesterday.
We still forget, though.
I now recognize Ms. Garcia, who's happier with what the Astros did last night.
Much better, Mr. Chairman. Thank you so much for this opportunity to examine the continued and longstanding barriers to voting accessibility for people with disabilities. As a young legal aid lawyer many years ago, I actually represented the Coalition for Barrier-Free Living here in Houston, which started working on some of these issues. And let me tell you, it is completely disheartening, Mr. Chairman, that we're still talking about the same things that we talked about back when I was in legal services in the late 80s. And that's been some time ago. So with that in mind, whether it's the ADA or local or state government requirements, people with disabilities should have full and full participation in all aspects of life. And certainly when it comes to voting, they should also have equal access without facing any barriers of any sort. I'd like to call your attention to an urgent problem that this subcommittee has held numerous hearings on, and that's, of course, is the voting rights, particularly for us here in Texas, for minorities and seniors' ability to vote. One in every 3 states in the country have passed voting restriction laws this year, as was noted by one of our witnesses. This is alarming. New voting restrictions could threaten seniors and people with disabilities, like my constituent, Erling Sullivan, who turned 102 years old recently. I visited her at her home, and she shared with me that even within her own house, one of her sisters is a Republican who's actually already insinuated that she's ballot harvesting because she has her sister, her daughter, help her with her mail-in ballot. Imagine the friction that causes in one's household when one sister is already accusing another sister of doing something that is always been acceptable, but now under the Texas voter restriction laws may be illegal. And then look at another one in our area, Nancy Crowther, a 64-year-old retiree who was disabled because of a neuromuscular disease, turned to mail-in voting in hopes of safeguarding her health during the pandemic. But because of the Texas GOP's renewed push to further tighten the state's voting procedures, Nancy had no other choice but to traverse a quarter of a mile in her wheelchair, navigating an uneven intersection and construction tunnel totaling approximately 3 miles just to cast her ballot in person so that she could avoid any accusations of voter issues. So it is clear that the law is not helping. In fact, the laws are hurting. So my first question is for Ms. Bishop. First, Ms. Bishop, thank you so much for continuing the work that's so important in this area. What ideally, what do we need to do? I know you've mentioned passing 2 bills. What else can Congress be doing to ensure that the states and the local communities do not do anything that hamper a person's access to the ballot, particularly for those with disabilities?
I love the stories first that you told about your constituents. I think they're so important because so many people who had an easy experience voting do not truly understand that that is not the experience of all voters, and that some of us jump through hoops of fire to be able to cast our ballots. I also really loved the story about the voter whose own family in her home are not necessarily supportive of her vote. And that, I think, is really important to point out, because I think we often hear a lot of things proposed that will make it difficult to impossible for people with disabilities to vote privately and independently, which is their federal right. And the excuse we always hear is that, well, people with disabilities will just have someone assist them. That is not what their rights are under federal law, first and foremost, but also not everyone has that, which your story illustrates. Not everyone has someone who they can trust to mark and return their ballot for them. We have to make the process as private and independent as possible. I did talk about a couple pieces of federal legislation in particular. I do think federal legislation can be very powerful for ensuring that we have good pro-voter policies in place that will ensure people with disabilities and all voters are going to have access to the vote and can counteract some of those policies. I did talk about the John Lewis Voting Rights Advancement Act in particular, because it would restore federal preclearance, which helps us stop some of those practices before they even begin, so that we're not waiting for a lengthy process of litigation to ensure that voters aren't going to be disenfranchised while elections are passing.
Well, thank you. And Mr. Chairman, I'd like to ask unanimous consent to enter the record an article, Texans with Disabilities Fear Voting Will Get Harder for Them, a special session on GOP restrictions nears.
Without objection, so entered.
Thank you. And I yield back, and I will submit a question for Ms. Klein that I did have on some employment numbers. Thank you.
You're welcome, Ms. Garcia. Our next congressperson to be recognized for 5 minutes is Ms. Sheila. Oh, Ms. Bush just got on. I'm sorry, Ms. Bush trumps Ms. Lee. Ms. Bush, you're recognized for 5 minutes.
Thank you, and good morning to everyone. St. Louis, and I thank you, Chairman Cohen and Nadler, for convening this urgent hearing on the importance of the Americans with Disabilities Act. For decades, disability rights activists have been sounding the alarm about how a lack of accommodations negatively impacts every aspect of their lives. Disabled people have been denied equal access to higher education, disproportionately struggle with mental health crises, suffer from police brutality at higher rates, and get denied opportunities for civic engagement and voting. As a nurse, I've seen firsthand how anyone at any time can become permanently disabled, whether you become disabled from elder age, an accident, a health crisis, or you're born disabled. This society should be built to accommodate your needs. Schools, businesses, transportation systems, and buildings have had over 30 years to get this right. 30 years. It's time to fight to develop universal designs for every single building and home that are designed to be accessible for everyone. Disabled workers are subjected to an abysmal sub-minimum wage that makes the self-sufficiency described in the ADA nearly impossible to attain. Low wages, more or less, guarantees disabled workers must live in poverty. Disabled people have to juggle sub-minimum wages while navigating higher medical costs, needing extra time off for appointments and treatments, and contending with a physically hostile environment. This is a shameful failure at every level of policymaking and enforcement. The buck, it stops here. Ms. Klein, in your testimony, you mentioned the issue of disabled workers' rights. Can you talk about some of the workplace accommodations and practices that support people with disabilities, particularly in the wake of COVID-19?
Thank you. And thank you, Congresswoman Bush, for your really sensitive remarks about the reality. You're very sensitive to the issue as a nurse background when you're saying the reality is that we all could become a member of the population of people with disabilities at any time. And it is the reality, this is us. This is a universal human condition. To your point, COVID-19 has been a major disruptor to the way everyone works. I'd like to say we're living in the golden era of more flexible, more autonomous, more distributed work. And yet we're talking about the very population of people that may have been the inventors of flexibility in work since 1990 and before, that have the least amount of investment in the infrastructure in order to have an even recovery from this pandemic. It seems that we're seeing a widening, a deepening inequality, an uneven recovery. People with disabilities were the first fired, they're the last rehired in this type of economic shock. And we have the majority of our equities in terms of public spend still channeled towards segregated, separate settings, when in fact there are many workers around the United States with disabilities who are reassessing their interests and their preferences for competitive employment and actually need more flexible technology, the infrastructure around broadband, but also the infrastructure around remote and distributed business tools, the types of technology that will allow virtual reality training. This is what other workers are doing right now. They're upskilling, they're reskilling, they're getting acclimated to a knowledge-based economy. There are so many workers trapped in historical anachronism. They're being trained in industries that are no longer pertinent to this knowledge-based economy. So we need to shift the focus of public spending to catch up, because the economy won't wait. And the expansion in knowledge-based jobs, upskilling and reskilling is of utter necessity now, and we need public investments to follow.
Thank you. Thank you so much for all of that information. Ms. Bishop, research from Rutgers University shows that 21.3 million eligible voters have mobility disabilities and 7 million have visual disabilities. What practices can local and state governments adopt to ensure their elections are widely accessible?
I think the number one most important thing we can do in terms of practices to make sure our elections are accessible is to include people with disabilities and disability rights organizations in the process from start to finish. We very often devise an electoral process and then show it to people with disabilities after the fact and say, look what we made for you. And it's not actually accessible. And we have to go back and try to retrofit something we've already built to make it work for everyone. We should be bringing everyone to the table and making sure that their voices are heard from start to finish, so that we're designing processes from the start that are actually accessible to everyone. I would also be remiss if I didn't say I was a St. Louisan before I came to DC, and go Cardinals.
Go Cardinals. Thank you. And I yield back.
You have every right to throw in the Cardinals. Mr. Carter took them out, I think. Ms. Jackson Lee, you're recognized for 5 minutes.
Chairman, thank you for this outstanding hearing, long overdue, and clearly a needed refresher course for so many about the crisis of living in America with a disability. This is a serious issue, so I will step aside because I cannot be restrained to say, go Astros. But let me move to the seriousness of this issue and the importance of seeing what legislative response we need to give. Let me quickly read into the record from the Centers for Disease Control. 3 in 10 American Indians have a disability. 1 in 4 African Americans have a disability. 1 in 5 whites, 1 in 6 Native Hawaiian Pacific Islander, 1 in 6 Hispanic, and 1 in 10 Asian. The disabled community is with us, and they deserve an ultimate quality of life that we, as part of the Democratic Republic, must ensure that they get. I will ultimately introduce into the record the inequities that are faced, particularly by those racial and ethnic disparities in special education, an article, Child Trends, that indicates the need to address those inequities as relates to dealing with children with disabilities, and discipline, if you will, the challenges that come about through placement and discipline of children with disabilities. Also, we'll discuss and enter into the record the article, Here's How Texas Elections Would Change and Become More Restrictive Under the Bill Texas Republicans Are Pushing, article dated April 21st, 2021, and then an article that has already been submitted, I'll speak from, is a July 5th, 2021, that says it's harder for us to vote in Texas with people with disabilities. Ask unanimous consent, Mr. Chairman, as I go forward.
Without objection.
Let me thank the witnesses, Patricia Lee, Regina Klein, Michelle Bishop, and Ms. Harned as well. Patricia Lee, let me thank you for your story. Let me tell you that SB 7 in Texas, words that I really don't want to say, it is not an election bill, it is a prohibition of election bill, but it would videotape people who are giving assistance to disabled people, allow them to be in the voting area with a camera. Can you, again, talk about how difficult it is in life at an assisted living facility where you used to live, and how your life changed, and how these living conditions may deny you your constitutional right to vote? Ms. Lee?
Yes, ma'am. I don't know how to answer that really, but I'm just gonna say I didn't feel very independent whenever I was in the assisted living facility. It was very depressing. It was not, I didn't feel, any kind of independence or accomplishment there. And through the help from Disability Advocates in East Point, TCLI have brought me so much more, have helped me to obtain goals that I didn't think I could obtain. And I see myself in a better place in the future.
Thank you.
Because yes, ma'am.
Thank you so very much. Was it harder for you to vote too?
I don't vote.
Well, it was harder for you to feel like a human being.
Yes, ma'am.
All right. Thank you so very much. May I ask Regina Klein and Michelle Bishop, again, a question of how we can further enhance the American with Disabilities Act on issues like voting and on issues about introduction and interaction in the retail and manual skills. What do we need to do to refresh or improve the Americans with Disabilities Act? And if the chairman would be kind enough to allow both of you to answer the question. Regina Klein and Michelle Bishop. Thank you, Ms. Klein.
Yes, thank you, Congresswoman Lee. And I would defer the voting issue to my colleague, Ms. Bishop, who is certainly an expert on that issue. To your other question, Congresswoman, we need not do anything to the ADA other than enforcement and vigorous enforcement. You know, I'm very troubled today by some of the comments made about ADA notification. You know, ignorance of the law is no excuse. At bottom, courts are very clear about the standards that apply to the ADA. On this issue regarding employment, it's very clear what the mandate of Title II of the ADA and Olmstead is. And it's really a matter of supporting state and local governments to comply, supporting the Department of Justice to vigorously enforce the mandate of Title II, and providing clear and unequivocal guidance as to how to do it. And so my answer is pretty plain. There is nothing that needs to be done other than vigorous enforcement as it relates to the very clear and powerful mandate embedded in the ADA and the integration mandate.
I appreciate that, and we will listen very carefully and engage. Ms. Bishop, would you follow up, please?
So Ms. Klein and I have very different areas of expertise, but we completely agree. There's nothing that we need to do to the ADA. The ADA works. What we need to see is vigorous enforcement by the DOJ. I agree completely. Additional guidance is always helpful. We see new issues arise in the world of voting rights all the time. Ballot drop boxes became one of the rock stars of the 2020 election, but they weren't always designed and placed accessibly. And that's something that guidance could be issued on to help elections officials to do that. In terms of the role of Congress, I would say absolutely funding for elections officials to meet the requirements of the ADA, fundings for organizations like our national network to provide them consultation to do that. That is our role under the Help America Vote Act, but also restoring federal preclearance that would stop in its tracks some of the legislation that you mentioned that really does threaten access to the vote for people with disabilities. Voting,
Did you answer that?
Yes, I do think it is important to amend and pass the Freedom to Vote Act that would establish protections for voters with disabilities as well as other voters and implement pro-voter reforms nationwide. I think it's important to pass the John Lewis Voting Rights Advancement Act to fully restore federal pre-clearance so that we can stop some discriminatory practices we're seeing arise in the states.
Thank you very much.
Thank you.
Thank you, Ms. Lee. Good luck with the Astros. That concludes our hearing. Everybody's had their chance to ask their questions. We appreciate the witnesses. Without objection, all members will have 5 legislative days to submit additional written requests and questions for the witnesses or additional materials for the record. With that, the hearing is adjourned.